A will. Most people believe that it is a testament to their life's work, and that when they drafted their will, they were prudently providing for those they love. Unfortunately, many of these people are wrong. Instead, a will guarantees that their estate will go through probate and be exposed to unnecessary hassles, delays, and expense. And a will provides no protection from incapacity or incompetency. During this brief discussion, you will be provided with basic information about the Revocable Living Trust and other planning tools that have helped people obtain greater control over their assets and their lives. After all, it really does come down to the question of control, of who will be in control of your assets. Will it be you? Will it be your family members? Or will your assets one day be under the control of the courts, the attorneys, or the government? With proper planning, you control what you have, and you control who will ultimately receive what you have. You control when they will receive those assets, and to a greater degree, you control and eliminate the unnecessary hassles, delays, and expense commonly associated with passing those assets on to your heirs. Without proper planning, you and your heirs could lose control. Control, instead, could easily be placed in the hands of attorneys, judges, and even politicians. And after they're done, it's safe to say that some of your assets will have disappeared. This presentation has three purposes. First, to help you gain a better understanding of two common potential problems that you and your heirs could one day face. They are probate and conservatorship. Second, to provide information on the Revocable Living Trust, the durable financial power of attorney, durable medical power of attorney, and the living will, or advance healthcare directive, as simple, affordable, yet extremely powerful methods for combating the potential problems of probate and conservatorship. And third, to motivate you to start the process of planning today so that you and your heirs can avoid these and other potential problems. Only attorneys can make legal recommendations and determine the suitability of a living trust in your specific situation. The purpose of this presentation is to provide general information regarding estate planning needs, such as the Revocable Living Trust. There are many critical issues or concerns that your planning should address. Potential estate taxes, even after their so-called repeal. Capital gains taxes. A potential double tax on your IRAs and other retirement plan money, just to name a few. We have chosen to limit the focus of this presentation to probate and conservatorship because they can have adverse consequences for almost everyone. What is probate? It is a legal procedure designed to supervise the administration and distribution of an individual's estate or assets after death. Probate isn't just a concern of the wealthy. It can have a dramatic effect on estates of $100,000 or less. Some of the types of property typically involved in probate includes a person's home, vacation property, timeshare, income property, savings accounts, bank CDs, stocks, mutual funds, municipal bonds, automobiles, recreation vehicles, boats, jewelry, wedding rings, collectibles, even life insurance can be subject to probate without proper planning. It may not come as a surprise that these and other assets can be subject to probate, but most people are shocked when they discover that probate fees are calculated on not just their assets, but on their debts as well. That's right. It is your gross estate, not your net worth, that is subject to probate fees. The logic behind what many would argue as being illogical is that because the court must make sure that all of your debts and obligations are resolved or paid before your heirs receive their inheritance, the fees must be calculated on the entire estate, including debts. These debts include the standard items such as credit card balances, installment loans, and mortgages. And they also include one additional item, the fees of probate. More than one estate has been forced into bankruptcy because the combination of the estate's debts and the probate fees was greater than the net value of the estate. Few assets escape probate when the time isn't taken to plan. Estates are subject to probate regardless of whether the person dies with or without a will. In fact, wills guarantee that your estate will go through probate. They are an engraved invitation to the probate court. And it is not just the unnecessary expense of probate that is of concern. You can expect a number of things to happen in probate court. For example, probate is the time and the place for contesting the will. It's when your will might have to be proven that it is legal. Probate is the place that creditors go to make claims against your estate. There are at least 3 reasons why many prudent people have chosen to rely on a living trust to avoid probate. Probate can be very costly. The process of probate can be time-consuming. And probate can be a gross invasion of your privacy. Some heirs have been forced to wait years before their inheritance was released from probate. And while they waited, they watched as 5%, 6%, even as much as 10% of their money vanished. And to make matters worse, probate can take a great deal of time. Even simple, relatively uncomplicated estates can take months, even years, to get through probate. During the delays of probate, your heirs are waiting to receive the inheritance that you worked so hard to provide. And while they wait, your estate is virtually an open book to the public. Anyone can go to the courthouse and read your will. Anyone can find out how much you were worth, what you owned, whom you left it to, how much you owed, whether you gave to charity, and perhaps of most concern, anyone can learn your beneficiaries' names, phone numbers, and addresses. Salespeople, scam artists, even criminals can uncover the most intimate details of your estate and who will inherit your assets. Fortunately, there is a relatively simple and affordable method to altogether avoid the unnecessary expense and delays of probate and protect the privacy of you and your heirs. It is with a revocable living trust. With a properly drafted revocable living trust, there are no unnecessary courts, delays, publicity, or lawyers. With a revocable living trust, if you die at 1 o'clock Friday afternoon, the successor trustee could be appointed by 1:01 that same afternoon. A revocable living trust, like a will, is a way for you to direct where your assets go upon your death. However, unlike a will, with a revocable living trust, your estate does not go through probate. How is the probate court avoided? A revocable living trust is a legal agreement that allows you to transfer all of your assets to your trust while you are alive. You retain control over the assets in the trust because you appoint yourself as the trustee. To understand the power of a revocable living trust, it might help to think of yourself as wearing 2 hats. You wear one hat as the individual who created the revocable living trust, and you can also wear a second hat as the trustee of the trust. While you are alive, who controls the assets in your living trust? You do. As the trustee of your living trust, you maintain full control of all of your assets. You can do with them what you want. You can buy, sell, encumber, trade, or do anything you now do with your assets. Beyond the ability to retain complete control over one's assets, what provides people with the greatest peace of mind is the knowledge that they can always amend, alter, or revoke their revocable living trust at any time. You should consider a living trust if the gross value of your estate exceeds your estate's probate limit, a limit as low as $10,000 in some states. If you have minor or adult children, you or your spouse have children from a previous marriage. You are concerned about a child's lifestyle or spending habits. You have a disabled child. You own or have an interest in a business. You own life insurance. You value your right to privacy. You want greater control over your assets today and after your death. You want your heirs to get your estate without unnecessary delays, attorneys, and courts. The bottom line is that if you want to avoid probate, you should consider a revocable living trust. While the revocable living trust has proven to be an extremely effective and affordable way to avoid unnecessary expenses, delays, and loss of privacy at death, people must also be concerned about the possibility that many of these issues could also arise while they were alive. Your planning should not end until you address the question of what happens if you become incapacitated. Let's consider this question in light of what may be a reasonably realistic example of a wife caring for a husband incapacitated by a stroke. Deciding to sell their large home and replace it with a smaller, more manageable home, she is confronted with the fact that she cannot complete the required paperwork without her husband's notarized signature. She could ask the court to appoint her to act as her husband's conservator, and while this would provide an immediate solution to the problem of selling the house, it will require her to petition the court, and it will require her to appear in court every year with an audited statement showing that she is managing her husband's assets properly and wisely. It will also mean that she will likely incur unnecessary expenses and fees for attorneys and accountants. Much of this potential hassle and expense could have been avoided with a relatively simple legal document, referred to as a durable financial power of attorney. A durable financial power of attorney allows you to name the person you want to handle your financial matters ahead of time should you become incapacitated. You can choose to keep the control of your financial affairs in your family without court interference. The durable financial power of attorney can always be modified at your discretion, and it only gives your agent the power to act if and when you become incapacitated. There are two additional documents that have proven to be valuable tools for families dealing with health care issues as opposed to financial issues. They are the Living Will, more properly referred to as the Advance Health Care Directive, and the Durable Medical Power of Attorney. The Living Will, or Advance Health Care Directive, is a document that you would use to state your wishes concerning whether to use, withhold, or withdraw life-prolonging procedures. The Durable Medical Power of Attorney allows you to pre-name the person you want to make healthcare decisions for you when you can't make them for yourself. These two documents can help you and your family retain control over your health care without interference from others. As we stated in the beginning, there were three objectives for this presentation. First, to help you gain a better understanding of the potential problems of probate and conservatorship. Second, to illustrate that the Revocable Living Trust, the Durable Financial Power of Attorney, the Durable Medical Power of Attorney, and the Living Will, or Advance Healthcare Directive, can be simple, affordable, yet extremely powerful documents for dealing with probate and conservatorship. And third, to motivate you to start the process of planning today so that you and your heirs can avoid these and other potential problems. It could be said that the third objective is the most important. The first two are valueless if you do nothing with the information. The choice is yours. A will guarantees that your estate will go through probate. It exposes your heirs' inheritance to unnecessary legal fees, unnecessary court costs, unnecessary publicity, and unnecessary delays. With a living trust, your heirs avoid these problems. They avoid the hassles. They avoid the delays. They avoid the publicity. They avoid probate. Which do you want for your heirs?